This is Lecture 10 of Principles of Company Law, and we'll be looking at governance again today, but we'll be focusing on the action of the members in the general meeting. So in order to look at the general meeting, first let's look at the powers which are retained for the members, and that's essentially powers which are not given to the board. And then the calling of the meeting has some relatively simple procedures, but they're procedures that we have to learn. And then voting in the meeting is something we've seen already, ordinary and special resolutions, but we'll look at it more closely, including a look at written resolutions. So shareholder power is what we're talking about, the exercise of power in the meeting. We have two organs for the company. One is the board, and the other is the general meeting. When we look at power, essentially what we have is concentric boundaries of power. So on the outer rim, we have what is actually possible. And that's not always what is permissible under the law, but simply what is possible for the members to do. And then we have members' approval requirements. These would be acts which are specifically named in the company's ordinance. A smaller subset would be the board's power. So the board acts within the member's power and does not reach the same extension as the member's power. And then the individual director within the board, which is the smallest. So what we'll be looking at in week 12, when we look at unfair prejudice actions, will be essentially actions that members may take, but are challenged as being unfairly prejudicial to the petitioner member or other members in the company. So one of the powers of the members is to control the Articles of Association, right? So we know that that can be amended with a special resolution. If the articles provide for share capital, then that may be amended with an ordinary resolution. We know that an ordinary resolution is generally a simple majority of votes cast, and a special will be 75% of votes cast. And also that class rights require a special procedure for amendment if they are expressed in the Articles of Association. This will generally be 2 votes, one by the entire body of members and then a consent vote by the affected class. The company's objects will be, if objects are stated in the Articles of Association, and we have the possibility of an objecting vote of 5%, and that will not be a controlling vote, but a vote which takes the matter to the court to decide. So beyond the Articles of Association, we have members' power also in changes to the capital structure of the company. So we need members' power, we need members' approval for the allocation of shares and also for a reduction of share capital. Reduction of share capital, remember, also involves the creditors or at least the court. And shareholders must authorize buybacks of shares as well. Right? So the share capital and the Articles of Association are parts of the company structure which are controlled by the members. Appointing directors and auditors are normally controlled by the members, auditors always, but directors' appointment will be specified in the Articles of Association, and that need not be the standard democratic formula. Although when we look at the model articles, we do have a normal annual vote by the majority of members on the appointment of directors. Now, the board can be staggered. We haven't really discussed this before. only briefly when we looked at the board, but essentially that would be, let's say we have a board with 9 members, and we have 3 members coming up for election every year. So in a cycle of 3 years, we would replace the entire board, but at any one time, we would have some very experienced directors, some directors with 1 year experience, and then newly entering directors. The auditors must be appointed by the general meeting, and that is specified in the ordinance. When it comes to removing directors, this is something that is specified in the ordinance, section 462, and also removing auditors is specifically provided for in the ordinance. So the appointment of directors is left to the contractual decision of the members when framing the Articles of Association, but the removal of directors will be something required by the ordinance in section 462. So remember also, we've just discussed this last week when looking at derivative actions, but members may ratify board action. So we have the possibility of ratifying director conduct, which could be a breach of duty or trust. And we also have the possibility of the ratification not preventing the filing of a derivative action, and also allowing the court to go forward to grant leave in the derivative action. So the members may ratify, the court will take that into account, but need not stop a derivative action because of ratification. So the court, as specified in 734 of the ordinance, will look at whether the ratifying members are connected to the misbehavior, and whether the members are acting for proper purposes and taking regard to the company's interests. So in any case, remember that when when a resolution is proposed to the members for their vote, they must be fully and completely informed of what they are ratifying. Some useful terms in general meetings will be the general meeting itself, which is abbreviated with the acronym AGM, Annual General Meeting, or EGM, Extraordinary General Meeting. So as the term indicates, the annual general meeting will be held annually, and essentially this will be the general meeting where the annual accounts are presented and directors are elected. Extraordinary general meetings will be meetings that are called for special purpose, aside from the annual approval of accounts, granting of dividends, and appointment of directors. The quorum will be the number of members who must be present in order to hold a valid meeting. Voting by show of hands is essentially a head count, in that each person, not each share, has a vote, where voting by poll will be by percentage of voting rights. So one person may own 99% of the voting rights, and another 200 persons may own 1% of the voting rights. And here that one person will have 99% of the votes, and the other 200 persons only 1% of the vote. A proxy is a power of attorney, and this allows a member to either simply vote by mail, that is, send in a vote indicating what that member votes on the particular agenda items, or send in a human being to the meeting to vote in that member's stead.